All right, kids, time for another episode of Hawk Droppings. Today we are going to go through and talk about the trial court decision. It's about 110 pages long that came out of a Colorado trial court a couple of months back in the middle of November on the issue of Donald Trump. Can he be removed from the ballot under Section 3 of the 14th Amendment? This is an incredibly important decision for many, many reasons. First of all, the holding in the case was that Donald Trump committed an insurrection against the United States. He incited violence at the Capitol on January 6th, and that Section 3 of the 14th Amendment does apply in this case, as applied to those facts. But the trial court judge, Sarah Wallace, determined that Section 3 of the 14th Amendment does not apply to the office of the President of the United States. That last part of her holding earned her a place on my first episode of Full Potato Friday because I think she chickened out. So that was immediately appealed to the Colorado Supreme Court, which affirmed her findings of fact, and we'll come back to that in a moment, but found that the Section 3 of the 14th Amendment does apply to the President of the United States. And they issued an order removing Donald Trump from the primary ballot for 2024. That order was stayed pending appeal to the United States Supreme Court. That appeal to the United States Supreme Court has been made. The Supreme Court has agreed to hear this case. Donald Trump just filed his brief in support of that case within the last few days. I'm recording this on Sunday morning, January 21st. And the U.S. Supreme Court is going to hear oral argument on this issue, I believe, on February 9th. So a couple more weeks. Why is this trial court decision so important? And why am I coming back to it? I'm going to go through it in detail. In this decision, first, it's important to realize that this decision came after this judge, Sarah Wallace, a trial court judge in the state of Colorado, held a trial. She held a 5-day trial, which involved testimony of witnesses. It involved introducing documents and other things into evidence, into the record. And she issued her decision after a trial took place where all parties were represented by counsel at trial, including Donald Trump. And, so it's like a lot of people on the right are saying, they didn't even have a trial. There's not been any conviction. Well, this was a civil action, not a criminal action. And so there are no criminal charges involved in civil actions. And so, but why it's important is the following reason. This judge, after hearing all of the evidence, after watching all of these witnesses testify and weighing their credibility and weighing the credibility and weight of the evidence in the case, issued in her order, in her decision, what's called findings of fact, meaning that after a trial, this judge determined these are the things that are factually true, according to the record. Now, that decision was appealed to the Colorado Supreme Court. And in our judicial system, we have trial courts, we have appellate courts, and typically part of the appellate court process is a Supreme Court. Whether it's a state Supreme Court, like here, we have the Colorado Supreme Court, or in the federal system, we have the United States Supreme Court. Appellate courts do not disturb the findings of fact. They do not disturb the factual record that has been determined either by a jury in a jury trial or by a judge in a bench trial. Why is that? Appellate courts will only overturn conclusions of fact if the trier of fact, be it a judge or a jury, did something that was clearly erroneous. like just blatantly erroneous. They made a finding of fact or a determination of fact for which there is no evidence in support of that in the record. Now, this judge, this decision, as I said, it's like 110 pages long. It is excruciatingly detailed. The questions of law that the judge goes through, she goes through in depth. The findings of fact, that the record of fact that she has created in this opinion, every single thing that she's like, the court finds the following. It is cited to evidence. It is cited to evidence in support of her determination that this sentence is factually true. It's an incredibly detailed written opinion. And the Colorado Supreme Court, when they heard this opinion, they did not disturb her record as far as the findings of fact. They overturned her on one conclusion of law, applied to those facts. The United States Supreme Court, in hearing this, meaning they did not find that any of her findings of fact were clearly erroneous. They did not overturn or reject any of her findings of fact. The Supreme Court is going to be stuck with that same record, her record of the findings of fact in this case, including that Donald Trump incited an insurrection against the United States and incited violence at the Capitol on January 6th. Why so much deference? Well, because either the jury or the judge in a bench trial was there in the room, watching face to face all of these witnesses testify, being able to weigh their credibility, or consider the weight of their testimony. Is their testimony relevant? Is it bullshit? Well, and appellate courts and appellate judges, understanding that they weren't there in the room when the trial took place, they give deference to the finder of fact who was in the room. It's either a jury or it's a judge if it's a bench trial. In this case, the trial was a bench trial. So we're going to go through this decision in detail, and we're going to focus on the findings of fact and some of the conclusions of law. It's just the factual record that came out of this trial is absolutely devastating for Donald Trump. It upends every single narrative. It tears down every single bullshit argument and piece of evidence that he says exists, which doesn't. Like the fact that, he continually, and he did this just a couple of days ago, even though he mixed up Nikki Haley and Nancy Pelosi, he blamed Nikki Haley for turning down his request for 10,000 National Guard troops at the Capitol on January 6th. He never made that request, and he prevented the Department of Defense and the Department of Homeland Security from providing that level of security for this event. So the decision starts out right out of the gate by saying this matter came before the court from October 30th until November 3rd. That was the trial. Party names. There are petitioners. They got a bunch of voters. This group called Crew got a bunch of voters to be the petitioners in this case. Donald Trump intervened in the case, so he's referred to in this document as the intervener. He was represented by 7. He was represented at by seven attorneys in this case. Then we go into the procedural background, which goes on for several pages. There were lots of motions to dismiss. There were anti-SLAPP motions. There were motions to do all kinds of things to prevent this trial from happening. But this matter proceeded to a 5-day trial beginning on October 30th, 2023, and concluding on November 3rd, 2023. On November 15th, 2023, the parties presented their closing arguments. I'm looking, if you want to follow along with this decision right now, I'm on page 8, section 2, the January 6th report. So petitioners in this case wanted to admit into evidence the final report of the January 6th committee in Congress that had their televised hearings over the course of 2022. And Donald Trump and his attorneys obviously fought that tooth and nail. And the judge goes through an exhaustive, a dozen or more pages about the question before this court is whether interveners have overcome the presumptive admissibility of the January 6th report. I'm not going to go through a ton of this stuff, but she goes through an extensive legal analysis until finally she gets to her conclusion that the committee report was legitimate, that it followed the investigative requirements of such a report in order for it to have credibility. Obviously, it's clearly relevant. The committee and its investigative staff interviewed or deposed more than 1,000 witnesses, collected and reviewed over 1 million documents, reviewed hundreds of hours of video footage, reviewed 60 federal and state court filings related to the 2020 election. Trump was subpoenaed and he refused to comply with the subpoena. The overwhelming majority of witnesses who the January 6th committee interviewed or deposed were Trump administration officials and or Republicans. And so her conclusion is that the court holds that the January 6th report is reliable and trustworthy and is therefore admissible, meaning that it is admitted into evidence in this proceeding, in this trial. And so it becomes part of the record. It becomes part of the official record. Then we get to page 16 with hearing testimony. And I found this section to be particularly interesting because when a trier of fact, whether it's a jury during a jury trial or a judge during a bench trial, when they're considering the relevance of witness testimony, the weight of witness testimony, the credibility of witness testimony, that's just part of like the deliberation process. In this decision, the judge made a record of it. She went witness by witness by witness by witness by witness. And she starts off by listing that Officer Daniel Hodges testified on behalf of petitioners. He was an officer with the Metro Police Department in D.C. He was on duty on January 6th. The court found Officer Hodges' testimony to be credible. The court gave weight to Officer Hedges' testimony in finding that there was an insurrection and that the mob was there on Trump's behalf. Congressman Eric Swalwell testified on behalf of petitioners. And she recaps them. The court finds that Congressman Swalwell's testimony regarding his experience during the attack was credible. The court gave weight to Congressman Swalwell's testimony in finding that there was an insurrection. Making this kind of a record for each witness makes this opinion that much more bulletproof. Officer Winston Pingen testified on behalf of petitioners. He was another officer on duty at the Capitol. This one caught my eye. Professor Peter Simi testified on behalf of petitioners. The court qualified Professor Simi as an expert witness in political extremism, including how extremists communicate and how the events leading up to and including the January 6th attack relate to long-standing patterns of political behavior and communication by political extremists. He testified that he has spent thousands of hours doing field work, including with the three primary perpetrators of the January 6th attack, the Oath Keepers, the Proud Boys, and the Three Percenters. The court gave weight to Professor Simi's testimony in finding that Trump intended and incited the violence on January 6th. Another expert, William Banks, testified for petitioners. In 2003, he founded the Institute for National Security and Counterterrorism. The court qualified him as an expert, and he is an expert. He's advised the Department of Defense and civilian agencies providing for emergency preparedness and response exercises to better prepare for crisis situations. He was qualified as an expert on the president's powers to stop domestic attacks on the government and the authorities that then President Trump had to call on to stop the January 6th attack. The court finds that his testimony was credible and helpful to understand the authority that Trump had over the National Guard in Washington, D.C., as well as any authority he had over the National Guard in adjoining states. The court gave weight to his testimony in finding that Trump had the authority to call in reinforcements on January 6th and chose not to exercise that authority, thereby recklessly endangering the lives of law enforcement, Congress, and the attackers on January 6th. Another professor, Gerard Malioka, he's an expert on studying the history of the 14th Amendment. He's written several papers on it. The court gave weight to his testimony in finding that Trump engaged in an insurrection. Timothy Heafy testified on behalf of petitioners. He's been, I think he's an MSNBC contributor now. He was the lead investigator for the January 6th committee. Chief Investigative Counsel. The court found him to be a qualified and seasoned investigator. The court gave weight to his testimony in deciding to admit specific findings in the January 6th report. Now we get to the clown car. Yeah. Now we get to the absolute shit show clown car of witnesses that Donald Trump called to testify on his behalf during this 5-day trial. And boy, howdy, do we start off with a bang. Kash Patel testified on behalf of Mr. Trump. Kash Patel testified that Trump had authorized 10 to 20,000 National Guard forces. The court finds that Mr. Patel was not a credible witness. His testimony regarding Trump authorizing 10 to 20,000 National Guardmen is not only illogical, but completely devoid of any evidence in the record. The court did not give any weight to Mr. Patel's testimony. Katrina Pearson was a senior advisor to both of Trump's presidential campaigns. She's a former spokesman. According to Ms. Pearson's testimony at a January 5th meeting at the White House, Trump agreed with her position that the speakers at the January 6, 2021 rally should not include inflammatory speakers such as Alex Jones or Ali Alexander. She also said that somebody in the room said something about maybe, 10,000 National Guard troops. The court gave weight to her testimony as far as who the speakers should be on January 6th. But did not give any weight to her testimony in any other regard. Amy Kramer testified on behalf of Trump. Ms. Kramer is the founder of Women for America First. They are the ones who set up the rally at the Ellipse and were later found to have lied repeatedly in failing to inform the Parks Department through the permitting process that, they're actually going to march down to the Capitol from the Ellipse. They knew that ahead of time and never said a goddamn word to the Parks Department about that or anybody else. The court found her testimony to be credible but irrelevant. And it goes on from there. Trump's another witness found his testimony to be credible but largely irrelevant. This Tom Bjorklund guy, he's a Colorado Republican Party treasurer. He attended the January 6th rally. He didn't see any violence. And his testimony was that Antifa was involved in the attack, which lacked credibility, and there was no evidence in support of that. Yeah. Congressman Ken Buck. I did not know that there were two congressmen who testified during this trial. I was not aware of that. We got Eric Swalwell. We got Ken Buck, one Republican, one Democrat. He gave some testimony about the January 6th committee and Kevin McCarthy's efforts to thwart the effectiveness and bipartisanship of the January 6th committee. And he is a Republican, and he blamed Kevin McCarthy for that. Now, page 25. So all of that stuff took up 25 pages. Here's the procedural history. Here are the witnesses. 25 pages. So this judge is creating an ironclad, locked down, watertight decision for appeal. She wrote this decision for the Colorado Supreme Court and for the United States Supreme Court. She has locked them in a box. And that gets demonstrated even more conclusively on page 25, section 4, findings of fact. She goes through the parties. Now, remember what I said about findings of fact as it relates to appellate courts. Appellate courts will not disturb, overturn, alter, change, or disregard a trial court's record of the findings of fact coming out of a trial unless one or more of those findings of fact are clearly erroneous with no support in the evidentiary record for that finding of fact. That did not happen in this case. Every single finding of fact that this judge determines, and her finding of fact section is like 35, 40 pages long. And we're going to go through it because it is a timeline and it is absolutely devastating to Donald Trump and to his supporters, frankly, that they're still supporting him with this document out there, having come out of a trial. And this is the record of the facts of what happened. And so the United States Supreme Court is going to be left with her conclusions, the trial judge's conclusions, that Donald Trump engaged in an insurrection against the United States and that he incited the violence at January 6th and did nothing to stop it or prevent it or bring it to a conclusion for over 3 hours. He sat in the dining room off of the Oval Office with his tiny little chubby getting off, watching people commit violence on his behalf. That's the record for the United States Supreme Court, and they're stuck with it. Even Thomas and Alito. There's nothing they can do to bail out their chunky orange buddy right now. Section B, page 26, Trump's history with political extremists. And this section relies heavily on the testimony of the expert witness, Peter Simi. Trump himself agrees that his supporters listen to him like no one else. Professor Simi testified about the following examples of patterns of call and response communication that Trump developed and used to incite violence by his supporters. And she goes through the history of his rallies that we all watched, where he was inciting violence against protesters in the crowd at his own rallies. October 23, 2015, there were protesters. See, the first group, I was nice. The second group, I was pretty nice. The third group, I'll be a little more violent. And the third group, I'll say, get them the hell out of here. At a February 2016 rally, Trump told his supporters to knock the crap out of any protester who threw tomatoes and promised to pay legal fees for them. Another February 2016 rally. In the old days, a protester would be carried out on a stretcher and that Trump would like to punch him in the face. When asked about his supporters' violent acts in March 2016, Trump said the violence was very, very appropriate and that maybe we need a little bit more of it. That's before he was even elected. At an August 2016 rally, Trump noted Second Amendment people might be able to prevent Hillary Clinton, if elected president, and judges appointed by her from interpreting the Constitution in unfavorable ways. August 2017, the Unite the Right rally in Charlottesville, Virginia, where a counter-protester was murdered. Trump said there was blame on both sides, some very fine people on both sides. Far-right extremists, including David Duke, Richard Spencer, Andrew Anglin, thanked Trump for his comments following that event and took them as an endorsement. May 2020, Trump threatened to deploy the military to Minneapolis to shoot looters amid protests over the killing of George Floyd, tweeting, "When the looting starts, the shooting starts." During a presidential debate in 2020, Trump refused to denounce white supremacists and violent extremists and instead told the Proud Boys to stand back and stand by, adding that somebody's got to do something about Antifa and the left. And in fact, following that, the Proud Boys turned that phrase into a mantra and put it on merchandise. The Proud Boys and other extremists understood this as a directive to be prepared for future violence. Trump also regularly endorsed and cultivated relationships with incendiary figures connected with far-right extremists, including Alex Jones, Steve Bannon, and Roger Stone. So again, this is a record of the facts as determined by this judge after listening to witnesses, watching witnesses testify, being in the same room with these witnesses as they testified, and seeing every single piece of evidence that came into the record. She is saying, based on all of that, these are the facts. And these facts will not be disturbed on appeal because of how well and how thorough she wrote this opinion. October 30th, 2020, a convoy of Trump supporters driving dozens of Trumps. Just envision that. Oh man, that was funny. October 30th, 2020, a convoy of Trump supporters driving dozens of trucks, calling themselves a Trump train with the flags and the poles and those guys, the small dick brigade, surrounded a Biden-Harris campaign bus on a Texas highway, hit the bus, and almost ran him off the road. Trump tweeted a video of that confrontation and stated in all caps, "I love Texas." At no point during this period of time did Trump ever credibly condemn violence by his supporters, but rather confirmed his supporters' violent interpretations of his directives. Professor Simi testified that through these repeated interactions, Trump developed and employed a coded language based in doublespeak that was understood between himself and far-right extremists while maintaining a claim to ambiguity among a wider audience. Page 31, paragraph 84. For example, violent far-right extremists understood that Trump's calls to fight, which most politicians would mean only symbolically, were, when spoken by Trump, literal calls to violence by these groups of people. Mob boss speak. 85, the court finds that Trump knew his violent supporters understood his statements this way, and Trump knew he could influence his supporters to act violently on his behalf. The court finds that Trump did not put forth any credible evidence or expert testimony during trial to rebut Professor Simi's conclusions or to rebut the argument that Trump intended to incite violence. He didn't put on any evidence to refute petitioner's expert that said he incites violence and this is how he does it and this is the language that he used and these are his intentions. And this is what his followers understand to be the case. He didn't put on any evidence to refute that. Again, Donald Trump has managed to cobble together an absolute army of the shittiest lawyers in the entire United States of America. And just as a little bit of a teaser, in this week's Full Potato Friday, we're starting off with Lena Haba, who's lead counsel in a multi-million-dollar civil case and said to the judge on the first or second day of trial, "I don't know how to try this case, Your Honor." She's the worst goddamn trial attorney I've ever seen in my entire life, man. And I've been doing this for 25 years. And I've seen some potatoes in a courtroom, let me tell you. Page 32, Section C. Trump's false allegations of a stolen election. And this is another thing that I appreciate so much about this opinion. She provides the history of his communication style with his supporters between the 2015 campaign and the 2020 election. 5 years. We just went through that whole section. Here's what his communication does. Here's what it means. Here's what he intends. Here's what his supporters hear and what they understand. All of that is the foundation for the 2020 election and his reaction in response to it. Trump planted the seed well before the 2020 election that any loss would be fraudulent. He portrayed the election as being stolen in a way that resonated with far-right extremists and aligned with their perspective that there's a corrupt system preventing them from electing somebody that they support and that the system is rigged. August 2020, the only way we're going to lose is if the election is rigged. The only way they're going to win is that way, and we can't let that happen. August 2020, mail-in voting is the greatest scam in the history of politics. Democrats are stealing millions of votes. The only way they can take this election from us is if it's rigged. September 2020, at a White House briefing, Trump refused to commit to a peaceful transfer of power after the election. Election day, and this was critical. This was an absolute flashpoint. It was like 2 o'clock in the morning. He came out into the White House press room using the White House. This was the day before Election Day. Excuse me. Strike that. I got a paragraph ahead of myself. The day before the Election Day, Trump criticized the U.S. Supreme Court for allowing Pennsylvania to extend the time for receiving mail-in ballots, tweeting that the decision was very dangerous, will allow for rampant, unchecked cheating, and will undermine our entire system of laws, must induce violence in the streets, imploring that something must be done. On election night itself, he came into the White House press room, and at the podium, he said, "This is a fraud on the American public. This is an embarrassment to our country. We were getting ready to win this election. Frankly, we did win this election. We did win this election." He tweeted, "We are up big, but they are trying to steal the election. We will never let them do that." The following day, he tweeted in all caps, "Stop the count." On November 7th, that Saturday, the election was called for Joe Biden. On November 8th, Trump tweeted, "We believe these people are thieves. The big city machines are corrupt. This was a stolen election." But throughout this period of time, Trump's advisors repeatedly told him that he had no chance of victory and that there was no evidence of widespread fraud to change the election results. Trump filed 62 lawsuits. 61 were rejected outright. The court finds that Trump knew his claims of voter fraud were false. Boom. Fact. He knew he was lying the entire time. The court has found that to be an adjudicated fact based on a trial record of evidence and testimony. And she goes on, he continues going on and on and on and on and on into late December, targeting specific state officials in swing states. Many of the state officials targeted by Trump's campaign for intimidation were subject to a barrage of harassment and violent threats by Trump supporters, prompting Georgia election official Gabriel Sterling to issue a public warning to Trump to stop inspiring people to commit acts of violence or someone's going to get killed. And so then this whole Stop the Steal became a movement nationwide. It became this organization. And between Election Day 2020 and January 6, 2021, it became organizers, and they held dozens of rallies around the country, inflaming Trump supporters with election disinformation and recruiting them to travel to Washington, D.C. on January 6, 2021. The rallies brought together many groups, including violent extremists such as the Proud Boys, Oath Keepers, Three Percenters, QAnon conspiracy theorists, and white nationalists. Boy, doesn't that sound like a party. And a lot of people forget this. In late November and in December in Washington, D.C., there were 2 million MAGA marches. And it was all Proud Boys, Oath Keepers, and these MAGA whack jobs who came from all over the country on November 14th and December 12th. And, and both of those rallies got violent and people got hurt. There were stabbings, there were beatings because, it's like these MAGA chuds and these groups had their rally during the day, and then when like 5:30, it gets dark, and they were just loose on the streets of Washington D.C. and they just went around beating the shit out of people. Anybody who they thought looked like Antifa. There were two of those. Trump drove his motorcade through one of them, and the second one he flew overhead in Marine One, the helicopter. Then on December 19th, Trump tweeted, urging his supporters to travel to January 6th. Statistically impossible to have lost the 2020 election. Big protest in D.C. on January 6th. Be there, will be wild. Trump's plan was that when Congress met to certify the election results, that Vice President Biden would reject the true electors that voted for Biden and certify Trump's slate, his fake slate of electors, or return to the states for further proceedings. Page 37, 115. The court finds. Whenever I say the court finds, that means the court finds the following to be a fact, a finding of fact. The court finds that on December 19th, 2020, when Trump tweeted what he tweeted, he knew that he had lost the election. He knew there was no basis for Vice President Pence to reject the state's lawfully certified electors. The court also finds that the December 19th tweet focused the anger he had been sowing about the election being stolen on the January 6, 2021 joint session of Congress. The message he sent was that to save democracy, his supporters needed to stop the January 6, 2021 joint session of Congress. Trump's tweet on December 19th had an immediate effect on far-right extremists and militias such as the Proud Boys, the Oath Keepers, and the Three Percenters, who viewed the tweet as a call to arms and began to plot activities to disrupt the certification of the electoral votes. Trump repeated his invitation to come to D.C. at least a dozen times. At the same time, Trump continued to make false statements regarding voter fraud, fueling the fire of his supporters' belief that the election was somehow stolen. By late December, he was tweeting that it was an act of war and that elected Republicans were too weak to do anything to stop it. And here we go. Let's talk about law enforcement and the FBI. And we still don't, maybe Jack Smith's got them. I've never seen the text messages and the emails from FBI agents and management leading up to January 6th. The FBI received many tips regarding the potential for violence on January 6th. Quote, they think they will have, one such tip said, they think they will have a large enough group to march into D.C. armed and will outnumber the police so they can't be stopped. They believe since the election was stolen, it's their constitutional right to overtake the government, and during this coup, no U.S. laws apply. Their plan is to literally kill. Please take this tip seriously and investigate further. Nonetheless, Trump did not advise federal law enforcement agencies that his speech was going to instruct the crowd to march to the Capitol. As a result, law enforcement was not prepared for the attendees and the rally to descend on the Capitol. That brings us to the day in question. In the early morning of January 6th, Trump tweeted, if Vice President Mike Pence comes through for us, we will win the presidency. Da-da-da-da-da. The court finds that prior to January 6th, Trump knew that his supporters were angry and prepared to use violence to stop the steal, including physically preventing Mike Pence from certifying the election. In fact, Trump did everything in his power to fuel that anger with claims he knew were false about having won the election and with claims he knew were false that Vice President Pence could hand him the election. That is just fucking devastating. It has been adjudicated by a court of law that Donald Trump was lying this entire time. That all of his claims were false. He was intentionally inciting violence to take place. He knew he had no factual basis to make any of these claims whatsoever, and he knew Mike Pence did not have the power to do anything about any of this. Page 40, Section D, the speech at the ellipse. And remember, there were about 50,000 people there that day, give or take, 50 to 55,000 people. About half of them went through the metal detectors to get into the area of the ellipse where Trump was speaking. About half of them didn't, because they didn't want to go through the metal detectors because a lot of them had guns. Despite what all the Gomer chuds on the right say, there were a shit ton of guns at the Capitol on January 6th. And from the 28-ish thousand rally attendees who passed through security checkpoints to enter the ellipse, the Secret Service confiscated hundreds of weapons and prohibited items, including 269 knives or blades, 242 canisters of pepper spray, 18 sets of brass knuckles, 18 tasers, body armor, gas masks, batons, blunt instruments, along with things like scissors, needles, and screwdrivers. Those are the people who were willing to go through the metal detectors. He does love the uneducated. The people who stayed outside of the metal detectors were not subject to any security screening whatsoever. Then they go through some of the excerpts of the speech itself, and we've all heard that shit. Got to fight like hell or we won't have a country, and if you don't fight like hell, you're not going to have a country anymore. So here's another interesting thing. There was a written text for Trump's speech that day that had been loaded into the teleprompter. During his speech, Trump called out Vice President Pence by name 11 times. In the teleprompter version of his speech, in the prepared text, Pence's name appeared one time. Trump used the word fight or variations of it 20 times during his speech. The teleprompter draft only contained one mention of the word fight. So he was ad-libbing, and he was adding the things that he knew would further incite his supporters. He made a statement that was not in the prepared speech, that the alleged voter fraud allowed his supporters to go by a very different set of rules. Knowing that many people in the crowd were angry and armed, Trump called on them to march to the Capitol and vowed to join them after he told them the rules don't apply to them. Rally attendees took Trump at his word and thought that they were going to join him. Thought that he was going to join them. Amazing. Amazing. People at the speech were screaming, "Take the Capitol, storm the Capitol," before they even left to march on the Capitol. It's a pattern of Trump's knowing encouragement and promotion of violence, referring to a political fight, but as rather a literal call to violence. Trump understood the power that he had over his supporters, and he's admitted that. The court found, page 45, paragraph 144. The court finds that Trump's ellipse speech incited imminent, lawless violence. That's for a Supreme Court case named Brandenburg. Trump did so explicitly by telling the crowd repeatedly to fight, and to fight like hell, to go to the Capitol. They needed to take back our country through strength. He did it implicitly by telling the crowd that they could play by a very different set of rules because of the supposed fraudulent election. The court finds that based on the testimony and documentary evidence presented, that Trump's conducts and words were the factual cause of and a substantial contributing factor to the January 6, 2021 attack on the United States Capitol. Page 46, Section E, the attack on the Capitol. And the crowd started marching to the Capitol before he was done speaking at the ellipse. They were led by a group of about 300 Proud Boys. Shortly before 1 p.m., Vice President Pence put out a statement saying, "I don't have the power to do anything that Trump is saying I have the power to do, and I'm not going to do that." At 2:13 p.m., the Capitol was breached, first by the Proud Boys, Dominic Pizzola. He's in prison now. The guy with the shaggy hair and beard and mustache who smashed through a window with a stolen police shield. The mob immediately moved towards the House and Senate chambers. The mob was armed with a variety of weapons, including guns, knives, tasers, sharpened flagpoles, scissors, hockey sticks, pitchforks, bear spray, pepper spray, and other chemical irritants. the mob assaulted police officers defending the Capitol to force its way into the building. Paragraph 161, the court finds that by sending otherwise nonviolent protesters to the Capitol building, along with the mob who was going to get violent, Trump materially aided the attack on the Capitol. Members of the mob told officers at the scene, Trump sent us. We don't want to hurt you, but we will. We're getting into that building. You look scared, and you might need you look scared, and you might need your baton. Take off your badges, take off your helmets, and show solidarity with we the people, or we're going to run you over. Do you think your little pea shooter guns are going to stop this crowd? It's going to turn bad, man. We have to get you out of here. The others are coming up from the back. The mob chanted, fight for Trump, and yelled into bullhorns, this is not a peaceful protest. Then the crowd displayed a makeshift gallows. They taunted police officers. They made repeated reference to 1776, revolution, and the Confederate flag. Page 52, Trump's reaction to the attack. At 2:24, Trump he tweeted, Mike Pence didn't have the courage to do what should have been done. The court finds that Trump's 2:24 p.m. tweet further encouraged imminent lawlessness by singling out Vice President Pence and suggesting that the attacking mob was demanding the truth. Congressman Swalwell interpreted that tweet as painting a target on the Capitol and on Vice President Pence. The court further holds that Trump's 2:24 p.m. tweet caused further violence at the Capitol. At 2:25, the mob breached the Capitol's East Rotunda doors. At 2:25 p.m., the Secret Service evacuated Mike Pence from his Senate office to a more secure location. At the same time, the House chamber and the Senate chamber were evacuated. The mob breached the Senate gallery. They didn't get into the House gallery, the House chamber. Trump did nothing between being informed of the attack at 1:21 p.m. and 4:17 p.m., 3 hours. Instead, Trump ignored pleas to intervene and instead called senators, urging them to help delay the electoral count while the crowd was chanting, hang Mike Pence. Trump rebuffed pleas from Leader McCarthy to ask his supporters to leave the Capitol, saying, well, Kevin, I guess these people are more upset about the election than you are. The court finds that Trump, as the commander of the D.C. National Guard, had law enforcement entities at his disposal to help stop the attack without any further approval. He could have deployed 340 National Guard troops who were already activated in D.C. He could have deployed D.C. National Guard troops. He could have spoken to the governors of Maryland and Virginia to get their National Guards. He could have ordered the Department of Justice rapid response teams to respond. He could have authorized the Department of Homeland Security to do the same. Trump provided no evidence that he took any action to deploy any of these authorities after learning of the attack on the Capitol. The court finds that Trump had the authority to call in reinforcements and did not do so. At 4:17, Trump put out a video. I know your pain. I know you're hurt. We have an election that was stolen from us. It was a landslide election, and everyone knows it, especially the other side. But you have to go home now. We have to have peace. We have to have law and order. We have to respect our great people in law and order. We don't want anybody hurt. 5 people were already dead by that point. This was a fraudulent election, but we can't play into the hands of these people. We have to have peace, so go home. We love you. You're very special. You've seen what happens when you meet a stranger in the Alps. You see what happens, Larry? Sorry, that's a Big Lebowski reference. You see what happens when you meet a stranger in the Alps? Inside joke. Sorry. Go home in peace. The court holds that Trump's 417 video endorsed the actions of the mob in trying to stop the peaceful transfer of power. It did not condemn the mob, but instead it sympathized with them. It praised them. It did, however, instruct the mob to go home, and the mob obeyed Trump's order. At 6:01 p.m., Trump tweeted again. These are the things and events that happen when a sacred landslide election victory is so unceremoniously and viciously stripped away from great patriots who have been badly and unfairly treated for so long. The court holds that even after the attack, Trump's tweet justified violence by calling the attackers patriots and continued to perpetuate the falsehood that justified the attack in the first place, that the election was stolen. The court finds that Trump's 601 tweet is further proof of Trump's intent to disrupt the election certification of January 6th. The court heard no evidence that Trump did not support the mob's common purpose of disrupting the constitutional transfer of power. By his video of 417 and 601, Trump endorsed and intended the actions of the mob on January 6, 2021. Then we get to some stuff about the Secretary of State, who has the authority to investigate. Then page 60, we get to conclusions of law. So conclusions of law is taking law and applying it to the facts. The first conclusion of law is that the Secretary of State in Colorado, based on Colorado law, does not have the authority to just remove Trump from the ballot. But this court does. Trial courts do. Then we get into some meatier considerations. Did Trump engage in an insurrection? Section B on page 66. Short answer, yes. The court finds that an insurrection at the time of ratification of the 14th Amendment was understood to refer to any public use of force or threat of force by a group of people to hinder or prevent the execution of law. Go through some dictionary stuff. Then paragraph 240, the court holds that an insurrection is used in Section 3 of the 14th Amendment is public use. Okay, 241, here we go. The court further concludes that the events on and around January 6th, 2021 easily satisfy the definition of insurrection. The mob's purpose was to prevent the execution of the Constitution so that Trump could remain president. Specifically, they sought to prevent the counting of the electoral votes. Then there's a whole bunch of analysis about certain language within the 14th Amendment about incitement and what does the word engage mean. And then she gets to one of Trump's defenses. It's the First Amendment. I was just exercising my First Amendment right to free speech. Trump, yeah. So that's where we get to the Brandenburg case. So that is a 1969 case that involves a Klan rally. And under the Brandenburg speech is only sanctionable as incitement if such speech satisfies the requirements of promoting imminent violence, intention to produce violence, and a tendency to produce violence. And the court already made that determination, but she goes through a pretty exhaustive analysis of the Brandenburg case anyway. And let me see here. And then she applies that analysis to this court. The court has found that Trump was aware that his supporters were willing to engage in political violence and that they would respond to his calls for them to do so. I mean, we all watched it on TV. He incited the attack. He did nothing to prepare law enforcement ahead of time. Once he was informed of the attack, he did nothing to stop it for over 3 hours. He resisted calls from advisors and members of his own party to intercede. The court concludes that Trump acted with the specific intent to incite political violence and directed at the Capitol with the purpose of disrupting the electoral certification. His inaction during the violence and his later endorsement of the violence corroborates the evidence that his intent was to incite violence on January 6th, based on his conduct leading up to and on January 6th. The court therefore holds that the first Brandenburg factor has been established. Regarding the second Brandenburg factor, the court finds that the language Trump used throughout January 6th was likely to incite violence. Consequently, the court finds that petitioners have established that Trump engaged in an insurrection on January 6th, 2021 through incitement, and that the First Amendment does not protect Trump's speech. So then we go through a pretty exhaustive analysis of Section 3 of the 14th Amendment and what constitutes an officer. And this opinion wraps up by saying, as a result, this court holds that Section 3 of the 14th Amendment does not apply to Trump, which this judge acknowledged in a footnote is probably wrong. Okay, good. I was hoping I would get through that in under an hour. So the Supreme Court's going to hear this on February 9th, a couple weeks from now. Trump has already filed his opening brief in the case. I have that. I'm going to read it. It's going to be complete bullshit. I mean, I think we're all aware of that. But I can't wait for that oral argument, and I can't wait to listen to the audio of that oral argument. And remember, I mean, I mentioned before, today's January 21st. We're all waiting on pins and needles from the decision that's going to drop any minute now from the D.C. Circuit Court of Opinion on the issue of, is Donald Trump immune from criminal prosecution for after leaving office for acts that he committed while he was in office. And we've all heard, the bullshit arguments that his folks made at the court that he's allowed to assassinate people. So it's just, it's exhausting, but, we'll stay on top of it. As things develop, I will let all of you guys know. So thank you, everybody, once again for tuning in. You can find my podcast. If I post this one to YouTube, you can find my podcasts at hawkpodcasts.com. And you can also get your Hawk merch at hawkmerchstore.com. Again, as always, massive thanks go out to my brother Falcon, who produces this whole thing and makes all the magic happen behind the scenes so that you guys can actually see and hear the things that I ramble on about for an hour or so. Huge thank you to him. None of this would exist without him. And thanks always to Wiseacre for our graphics, and for my good buddy Ani for letting us use some of his music in our intros. So I hope everybody has a good upcoming week, and be safe. Try to stay sane. Take care of your mental and physical, emotional and spiritual health through all of this, because it ain't over yet, and this year's going to suck. Okay. Have a great day.